Welcome to Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our website is libertylawtalk.org, where you can subscribe, comment, find other episodes and links relevant to today's conversation. Our email address is mail@libertylawtalk.org. We'd love to hear from you. Today we are talking with Professor Marc Degirolami of the St. John's University School of Law about his new book, The Tragedy of Religious Freedom, recently published by Harvard University Press. Professor Degirolami has an extensive record of academic publications and also, and I don't know what to think about this, frequently writes for the New Republic, and he is a contributor to a blog I like, Mirror of Justice. So, Marc, it's great to have you today, and I look forward to discussing your book.
Thank you, Richard. I'm delighted to be here. Thank you for having me.
Marc, I want to ask you a question from the beginning. The title of your book is very instructive, The Tragedy of Religious Freedom. But before we get into the meat of your book and your analysis, a basic question for you. What do you think is going on in that first Congress that debates, ratifies, that frames the religion clauses of the First Amendment?
Well, that's a very interesting question, Richard, and unfortunately I have a muddy answer to it, and that is I don't think much is going on in that first Congress with respect to the religion clauses. The first Congress had bigger fish to fry than deciding on what was going to be the relationship of the state to religion. They also had intense disagreements both regionally and actually from state to state. And so there is a theory, a very persuasive theory, that what they had in mind with the religion clauses is basically to freeze that disagreement. They needed to take care of other matters. They had a country to run. And concerns about religion and state were fraught. They were contested. People disagreed about them. They knew that what they didn't want was a Church of the United States of America. They did not want a national church, so at the very least, we know that, for example, the Establishment Clause was meant to stop that, or was meant to prevent that.
But a national church, you're saying?
A national church.
Okay.
A national church. So
state churches persisted for almost went to the 1830s.
Established churches persisted through to the 1830s, and at least at that moment there, in the first Congress, the idea was again to preserve that disagreement, certainly not to solve it in any way that, because they wouldn't have been able to solve it. They would have had, if they had really stood on some particular principle or value or conception of church-state relations, we wouldn't have seen a set of religion clauses enacted in the first place.
So your answer, I think, raises a lot of questions. I mean, one is just the relationship of the overall Bill of Rights to the structure of the Constitution, and the motivations for bringing it, to appease the anti-federalists is the historic conventional answer, has a lot of truth to it, and then also thinking about the religion clauses and how they relate to one another, and the Establishment Clause and the Free Exercise Clause. And so which one is there one that has preeminence over the other? I mean, is it the case, as some have said, or do you think that the Free Exercise Clause is preeminent and the Establishment Clause is meant merely to protect that free exercise?
No, I wouldn't say that either is preeminent or dominates the other. I would say that, and this is something I talk about in the book, is that the meanings of both clauses, there's sort of a core meaning that everybody would agree, a very relatively narrow, I would say, core meaning that everyone would agree was covered by each of the clauses. So, for example, in the Free Exercise Clause, it was widely understood that clause was going to protect the freedom of individual belief. So now that may sound like not such a big deal today. We might think, well, of course, how could anybody, why would anybody care about, and why would anybody be concerned about protecting individual conscience or belief? But in fact, historically, that was a very big problem. You had states persecuting people for their individual beliefs, and so that was something that was certainly on the minds of what had been Englishmen in the late 18th century. But aside from those narrow core meanings in both the Establishment Clause and in the Free Exercise Clause, there was contestation about what the proper relationship between religion and the state ought to be, and there were for example, some additional meanings. I think Michael McConnell has done some excellent work describing maybe 5 or 6 core meanings that the Establishment Clause was thought to cover. Beyond that, there was just difference among the colonies. You had Anglican establishments in the southern colonies. You had Congregationalist establishments in the northeastern colonies. You had Rhode Island as a kind of an outlier that had its own very unique take on what religious liberty was ought to mean. So you had a broad set of views, differing set of views about what those clauses ought to cover.
Okay, I was as I read your book, and I want to get into it now, but I guess a question that I want to leave is the religion clauses has, as John Courtney Murray famously describes them, articles of peace versus being seen as articles of faith. And he attributes the articles of faith, one, to both a secular mindset, but then also a liberal Protestant mindset that sees them as really exemplifying religious practice itself, which would tend to exclude, say, a Roman Catholic understanding, Roman Catholic ecclesiology, and that relationship with the state. And as I move through that, it does seem more and more there is a renewed attempt of these clauses being seen as articles of faith, particularly in certain acts of the Obama administration. It seems to me that it's actually something other than a reconciliation or an attempt to preserve a space for free exercise. That's something that just kind of hovered in my mind as I was reading your book. Now, on to what you argued, you set forward 5 theses for managing and deciding religious liberty conflicts. But before we get into that, describe, if you will, where you think scholars in this area have gone wrong.
Sure. So one of the basic points of the book, I would say maybe the critical thesis, overarching thesis of the book, is that the problem with modern scholarship about the religion clauses is that it proceeds in some ways from the top down, what Richard Posner once called the top down, so that it will select, scholars will select a value, single value, or sometimes a set of values,
like equality,
like equality,
okay,
or separation, or neutrality, and there are others, or for example, the preservation of civic peace. So they'll select a value, and then they will superimpose that value on all of the conflicts of religious liberty that will come before a court or the Supreme Court, and they will decide cases by examining the controversy through the lens of that value, so that a conflict in which you have 2 sides, let's say it's the state and an individual believer, or the state and a religious institution, in conflict will be analyzed through a particular egalitarian lens, and will be decided by reference to a particular egalitarian principle. And so the idea is this is the right way to go. In fact, the idea is to reduce these conflicts of religious liberty to debates and arguments about a particular value, a particular concern within the ambit about what religious liberty has traditionally covered, or has been thought to cover. And so the critical part of the book says, that's wrong. You shouldn't do that. You shouldn't analyze these conflicts from the top down. And the reason is there are too many values that pertain to religious liberty and that ought to pertain properly to religious liberty under the Constitution that are in conflict. And here I adopt some of the insights of some of the value pluralists who have been writing in areas really largely other than law, and certainly areas other than religious liberty, to say, if you do that, if you analyze these conflicts through a single value, you boil down concerns of religious liberty to a single value, you will lose important, worthwhile concerns, values, historical considerations that have mattered to people who have been committed to religious liberty across time in the process. You will lose them systematically. So that's bad. We shouldn't want to analyze the conflicts of religious liberty in those terms, and that's the problem. To answer the question in sort of a long-winded way, that's the problem that the book identifies with much of the scholarship that deals with religious liberty today.
I guess a couple of cases stand out as you're talking about this. I mean, the big one, I think, is Employment Division versus Smith.
Yes.
Would exemplify this, I think, through neutrality. But of course, the end result of Smith, and Smith has been blunted in a lot of different ways. I think the full harshness of the opinion has never really been brought to light. But the end result of Smith, if you work through the analysis and apply it consistently all the way down, is something like a highly secular society. With a very small room for religious liberty. But also, just thinking of the Hosanna Tabor case, which the administration lost 9-0 of. You could see. I'm seeing like 2 or 3 different monistic values that the administration was arguing from there, and of course, this still had to do with the ministerial exception.
Yeah, no, I think that's right. So, and just to take those 2 cases, I'm critical of Smith in the book. I believe it to be an example of what I call a comic approach, and this comic approach really involves the sorts of reductive exercises that I talked about, that scholars are engaged in what I just mentioned before. And Smith reduced the values of free exercise under the Constitution really to a single value, and that value was formal neutrality. And the court said a neutral rule that is applied generally can no longer violate the free exercise clause of the Constitution, no matter how severely the rule is burdensome to religious free exercise of an individual or a group, and no matter how insubstantial the government's interest is in enforcing the rule on a religious claimant. And so the Smith decision is one of the decisions that I criticize on the free exercise front as exemplifying a comic approach. Justice Scalia wanted in Smith to bring a kind of system to the law to eliminate the interest balancing approach that preceded it. And it did that by reducing the values of the social practice of free exercise to exactly 1. And it also ends up, in the process, distinguishing prior case law in completely unconvincing ways by marginalizing the values of religious freedom reflected in those conflicts in those cases. Hosanna Tabor is a case that I don't like the administration's position, but I do like where the court ended up. Yeah. I think Hosanna Tabor exemplifies this. So that I had mentioned there's a critical feature of the book, and then there's a constructive feature of the book, and maybe it would work to explain a little bit from the ground up why I think Hosanna Tabor is positive. To illuminate or to show up the sort of method that I like. Hosanna Tabor was a nice case methodologically from my point of view, because it's a case that focused very much on historical and particular legal and social realities. So Hosanna Tabor was a case that specifically refused to elevate a single value to all-important or master status. The court expressly says that in this first opinion, where it is discussing the ministerial exception, when it's trying to decide when an employee qualifies as a minister, it's not going to adopt a rigid formula. That's the part of the opinion that I think is consistent with a tragic approach. Instead, after a fairly thorough discussion of the foundations of the ministerial exception in the historical traditions of American religious freedom, the court really undertakes what I call in the book a suite of inquiries, which is, I describe this as a really highly particularized set of questions about the nature and function of what the plaintiff did. Now, the court's opinion isn't perfect. I disagree with some of the conclusions that it reaches about, and even I wish that it had asked some questions that it didn't ask. But the overarching method of the decision is as close to my approach as any of the court's opinions. That is, it's an opinion that really takes historical practice seriously and really asks some very specific, particularized questions as it's trying to sift and lift up for public inspection the values in conflict.
I want to briefly mention, so the flip side, we've discussed now the monist and the comic approach, as you said, to resolving religious liberty disputes, but you also bring in the skeptics as well, and right skeptics and left skeptics, skeptical of there even being such a thing as religious liberty, and almost as if, is there even such a thing as religion? In fact, you discussed that with some religious studies scholars. So on that front, the skeptics giving us any sort of leverage to work with in resolving these disputes, or where are they going wrong?
Yeah, so I think that's exactly right. There is this flip side of scholars. The other side of scholarship in this area is that we're either given a single value approach, a monistic approach, or we're given a skeptical approach. And the skeptical approach tends to say, look, there are no values, no constitutional values of religious liberty, either because the commitments that support the commitments that support a conception of religious liberty are now gone. In the sort of postmodern society that we live in, or in the increasingly secular society that we live in, or what have you, we've lost sight of and lost the ability to access what it is that gave us a commitment to religious liberty in the first place. That's one possibility. Or the second possibility that the skeptics propose, different set of skeptics, is that the category religion is itself a kind of fraud category. It's a category that Western colonial powers created in order to sort of dominate and subjugate peoples whose commitments with respect to what we traditionally think of as religion differed from that of the colonists. So religion, in this view, is a kind of hegemonic instrument to tame to tame and subordinate people who need to be conquered. So that's a kind of the other approach. Oftentimes there are some religious studies scholars who make these claims, or a related claim is that religion is a scholar's category. It was a category created by scholars in order to study certain phenomena that they observed in different societies. So, for example, the category world religion was just a category that was created sometime in the 19th century by Western scholars who traveled to distant lands and noticed, weird things going on that they wanted to study, and they came up with a category religion. So, the book criticizes some of these views principally because it particularly criticizes the second category of these views that I've described, principally because there is just an enormous distance between what it is that religious studies scholars do and what legal scholars do. Legal scholars manage an existing set of social practices and social structures, organize them so that people can live well within them, so that people can predict what it is, make projects, what it is that the state will do, think about how to live well within an existing social structure. Yeah. Religious studies scholars do something else. They want to explode those structures. They want to get past them, think in new ways, dissolve the category of religion. That's not going to work for law so well, because people depend on the categories that they know in order exactly to live a good life. So it would be as if all of a sudden somebody came along and said, actually, there are no such things as buses. That's just a fraud category. And that means that the government can no longer provide public transportation. Well, I mean, people rely on public transportation and buses to take them where they want to go. They've made a plan for their lives, and if you're going to come along and tell them that there actually are no buses anymore, you're going to leave them in the lurch. That's what law is for, in some sense, not leaving people in the lurch, allowing them to plan, allowing them to structure their lives within an existing social apparatus.
I'm puzzled. I mean, there's a lot of different thoughts I'm having about the religious studies scholars. I mean, their views seem so fantastical to me. I don't know if I want to waste too much more time on it, but I say that jokingly. But I think, I mean, is the project here or goal here something like privatization of religious belief, that it's something everyone does, but it doesn't have any sort of group, collective, social content to it, or because in one sense they're really rejecting, because I mean, I'll say the achievement of the West, I think, is to separate the two spheres and acknowledging their relative autonomy, because law and politics is something we do as human beings, but so is religion, or the quest for meaning, and to try and relate those to one another in a separate sphere. And I think to then reduce that, either if you're trying to say religion doesn't really exist, or it's something people do, but it's not important. I mean, I guess I'm not sure where they're coming from, but it seems just like a reversion in progress or something.
Well, I think, and I should say immediately that I think their projects, they're important projects. They have immense value, what the religious study scholars do, in as much as, but they're different projects than those of the legal scholar. So it might be, as you say, Richard, that one possible end of this is to privatize religion, but it might be also to say, look, let's get rid of something like the Establishment Clause. What does it really mean to establish religion? It doesn't mean anything. Let's start thinking about some of these issues that we've been thinking about for so long by reference to other values, for example, like equality. Maybe we can reconceptualize some of the things that we've talked about for years and years as involving the Establishment Clause as really something that could involve the Equal Protection Clause, for example. So there is, I think, it's not necessarily a move to privatization. I think it's a move to dissolve the category of religion as being legally useful, but then the question is what replaces it? What replaces it so that people, I mean, you leave people in the lurch if all of a sudden you wipe clean the slate of laws that has existed since the time of the American founding.
Yeah, I mean, I think, and I do want to get into the legal analysis you put forward in your book, which we've kind of touched on, but under this idea of the 5 theses. But I mean, that kind of raises the question, I think, and it's something that I had in my mind as I'm reading your book, and particularly your reliance on doctrinal and social history. Just thinking about, well, what's the core commitment here? And just hearing things about, so we could dissolve the category of religion, but since religion arises from something within the human spirit. That is to say, my reason asks questions that are probative, which it doesn't really have the resources to answer. So reason can ask the question, why did I come into being? But it can't really answer it. And it seems that's fundamental to human meaning. And then, of course, related to that is, I'm not going to do this alone. I'm going to do this in groups. We're going to create symbols, or we're going to refine them. We call those creeds after a while. I mean, things like that are going on, and so I think this kind of gets at, so what's good about religious liberty, or what's truthful about it, is something that's preeminent for me. I wanted to read page 3 from the book, which is obviously the opening, and just thinking about the 5 theses. And really just and get your comment on that as we move forward here.
Sure.
So you say the clash of values. So first, the clash of values of religious liberty, that the values which swirl around the conflicts of religious liberty are incompatible and incommensurable. Second, the inadequacy of skepticism, that notwithstanding the perpetual clash of values, a hard skepticism about the possibility of a principled approach to religious liberty under the Constitution is unavailing. So we've been talking about that, I think, with the skeptics.
Yes.
And also the first one, I think, really goes to the monists. Third, loss, sacrifice, and the disposition of custom. That the disposition or quality which issues from the clash of values of religious liberty is keenly attuned to the losses and sacrifices entailed in legal decision-making, as well as the role that habit and custom play in the formation of conceptions of religious liberty. So what exactly are you getting at there in terms of clashes about religious liberty and then bringing in this habit and custom and et cetera?
Yeah, well, so let's talk about that third thesis. So, and it relates to some of the things that we've been talking about a little bit with the skeptics as well, that part of the value, when we talk about religious freedom, because you have these so many values that clash in various ways, and because as a result you should not want systematically to privilege any one of them, what do you do? Well, you have to think about why it is that religious liberty has value to people. Well, people are very committed to their religious traditions oftentimes. They, at least at the time when they're advocating, for example, legally, they're certainly very committed. They may change their minds later. They may choose other traditions. Then those will be the traditions that they're committed to. So they have developed a habit, a custom of shaping, organizing their lives around adherence to a particular set of tenets, set of beliefs. They have developed what I call in the book a customary disposition toward both their religion and toward, as a result, because I always link these two, you can't talk about religious liberty without thinking about exactly, what kind of religion are we? What is religion in some sense? And so, if religion is this protean set of commitments, habits, and so on that people are devoted to, what legal thinkers ought to factor in more in their analysis about why it is that religious liberty has value is this customary disposition toward customary disposition, orientation toward the reasons for valuing religious liberty in the first place, right? So we talked a little bit before about people rely on religious liberty to organize their lives, to pursue the good life within the framework of religion that they have adopted and that they are devoted to. That ought to matter for legal purposes, and it will matter methodologically. It will matter because once you adopt that kind of view of why religion matters, inevitably that's going to shape doctrine. And so it's a disposition that depends on historical traditions, mapping those out, seeing how they operate within particular religious traditions, to then create a kind of gradual, incremental, almost like a common law approach to matters of religious liberty.
I liked the discussion of, as I'm reading your book, I'm thinking of this guy, Edmund Burke, and you actually work him into your analysis and describing, I think, more the way of the fourth and fifth theses, which we can get to. But I think the crucial point there is, which I think is forgotten in an individualistic age or a incredibly secular age, is we're actually born into habits and customs. We are born into and acculturated, as it were. We aren't just kind of sovereigns, and I think that is certainly a part of your analysis, which is incredibly truthful as well.
I'm glad that you say so. Thank you. And Burke is a very important thinker for my approach because, and I think I say this somewhere, people are born into certain traditions and they adopt certain customs, and then the rejoinder is, well, yes, but they can change those. Oftentimes they reject those, but the point is, yes, but they choose others. Mm-hmm. And then they are shaped as much as they shape those traditions. They're shaped by those traditions, and And again, if that's the way that religious commitment and religious affiliation works, or often works, or even sometimes works, then it ought to be the sort of sociological fact that is contemplated by, worked into any particular theory of religious liberty. It ought to be attentive, theory ought to be attentive to the sort of on-the-ground experience of what it is that, why it is that religion has value, and therefore why religious freedom has value.
It is interesting thinking about what you've said, and yet the nature of religious movements in America, say the last 20 or 30 years, in that you have an expansive evangelical Christianity, which I think, and you could argue they're kind of, with some of the separation decisions of earlier in the 20th century, kind of brought out of hiding, or brought out of their slumber, and become very active in American politics. But yet there's these clashes, I think, particularly you see this in the public schools, where it just seems intractable, of actually an expansive religion that actually wants to propagate and spread its faith in various secular contexts, and there's an inherent clash there. And I wonder, your method, I wonder what resources it gives us in that context, because it seems to me it's just something. I don't know if it's new to say that. I mean, that there wouldn't be new in American history. We're obviously a nation colored by revivals of a kind, but new in the sense of it seems to be somewhat strange to a secular society to see this happen and to kind of adjust to it. But it's something that is a part of what we're doing as well. I want to go on to the fourth. And you say fourth idea is the need for modest movement in deciding religious liberty clashes. And you say that's because of the tragic conflicts which attend many religious liberty cases. The best approach is gradualist and incremental. Talk about that, how you see that.
Sure. Well, so this is in some ways to counter or in denial of primarily the monistic approach that I criticized earlier. I don't believe, I think it's a mistake to try to imprint a single value across all of the conflicts of religious liberty that come to court. And instead, as we talked about Burke a little bit, I believe that it's better to adopt a historical kind of perspective on the ways in which a particular conflict has developed. And I don't mean just within the confines of the specific dispute, but for example, if you take a conflict like the one coming up in front of the Supreme Court about legislative prayer, it matters to my approach that the United States has had a practice, and largely undisturbed. There's no period of time in which the practice was sort of, went out of fashion or didn't happen for a large chunk of time. A practice, social practice of legislative prayer, of presidents issuing prayers and proclamations that involve religion, that makes a difference to my approach in a way that it doesn't, I don't think, to competitor approaches. It doesn't it's not dispositive. In other words, it's not just because a practice is of long standing and extremely popular doesn't mean that it's always going to be constitutional, but it ought to give it a presumption of constitutionality, in my view. It ought to be something that courts countenance and struggle with and explain why it is that a particular legislative prayer practice is so inconsistent or otherwise problematic that the presumption of constitutionality, given the historical roots of a practice, ought to be overcome. That's the kind of approach, I think, that one sees in some other areas of the Supreme Court's jurisprudence, and here I'm thinking particularly of the issue of the right to die and the assisted suicide cases. But one doesn't see it so much in the religion clause cases, and one certainly doesn't see it in the scholarship about the religion clauses. For my approach, it matters. It matters a lot, and if we're going to move away from a practice with deep roots, you ought to explain why, and you ought to do so in a way that moves gradually. After all, these practices have been in place for many, many years. They have established, you want to talk about neutrality, they've established the baseline from which neutrality can be assessed. If all of a sudden you remove, you just destroy a particular practice that people recognize and know as within the social tradition of a country, that hardly seems a neutral approach when it comes to religion. So that's how that component of my approach would work.
And then, this raises what I think is an important question, which I want to get to. I want to just mention this fifth idea here: the conciliations of history. You say that in light of tragic conflict, and we can talk about the ways you use the word tragedy in this regard. Courts should use doctrinal and social history as guides to legal change. Now, I guess as I'm reading your book, and I'm nodding my head, and I'm thinking this is prudent. This is common sense. This seems common sense in not just a lightheaded way, but actually something that takes into account a lot of different factors that are circulating at any moment and tries to make some sort of harmony with them with regard to law. As I'm reading this, I'm thinking about an argument you've put forward that's something or an observation that we always lose something in a religious liberty dispute, no matter how it's decided. Something is lost and may not return. And one of the things you say is judges should write their opinions accordingly, such that your minimalist approach, but that so it's not actually discredited or disgraced because who knows, it might return. And the practices of the people, and you want to give value to that again. My question is, though, in talking about what gets lost, let's talk about what gets lost with the incorporation of the religion clauses against the states. Because as I read your book, I say, yes, but this is actually, if you connect it to the structure of the Constitution, these are decisions that should be made by state legislatures, local town councils, etc., on behalf of their constituents who are the sovereigns. And because that's what we're really talking about here. It's their practices. It's their voices. It's their ways of life that are at stake here. And it should actually be the representation, that process of representation that gets decided. But of course, incorporation isn't going away, so I know there's a problem there. But that's a question I wanted to put to you.
Yeah, so I agree. Certainly, I agree with much of what you say, and as to the last point, I agree. Incorporation is not going away. The incorporation of both clauses is something that's here to stay. And in the book, I use a metaphor to try to get at this idea of minimalism, but with limits, if you know what I mean. So in order to preserve some of in fact what the Establishment Clause plausibly has been interpreted to have wanted to preserve at the time of its enactment, that is some local difference in religion-state relations, I use a metaphor of a meteorological metaphor, and I use the metaphor of a kind of lightning strike. The Supreme Court should allow, as it is looking at some of these conflicts around the country, and in keeping with its minimalist approach, should allow a certain amount of variation in local practice. That doesn't mean that it should sort of adopt an anything goes approach, but it should allow a certain amount of so that different climates can exist in different parts of the country. When the conditions are such that are particularly propitious for rain, then rain will be predicted, and maybe even a lightning strike by the court will be predicted, and be predicted accurately. not with 100% not with 100% accuracy, just as the weather can't be predicted with 100% accuracy, but pretty well. If you really go afoul of a core commitment of the Establishment Clause, we can with a high degree of probability predict a lightning strike. But if you don't, if you are only testing certain limits, borderlands of the Establishment Clause or of the Free Exercise Clause, then those might be situations in which we would ask for a more restrained, a more minimalistic approach by the court to say, hey, look, let that lie. Sure, it's different in Texas than it is in New York, right? But that's part of the, as you say, the structural commitments undergirding the government itself. That we ought to have a little bit of federal variety within federalism when it comes to questions that at their very core and at the very beginning were and continue to be contested.
I'm just in thinking about the doctrinal approach, which is heavily incorporates history, practice, social history, has a heavy use of precedent. You're calling for also, I suppose, a new common law approach to religious freedom, or actually, I was supposed to recall what was happening before, say, early 20th century disputes about religious liberty, and then sort of the balancing test that you saw in a lot of the free exercise cases, and then extending that approach. I guess, but my question also is, and I guess this still comes down to something that's in my mind about the core commitment. So do we care about religious liberty under your approach if, say, social and history of America start to change? Say we do become more like, some people are saying we're going to become more like Europe. Becoming Europe, right, is a popular book right now.
Right.
And we move in that direction. And do we care if something's lost? Because really there's more and more what you would find yourself appealing to are, we've got this history of religious freedom, but you got to get out the history books to find it, because we're not really interested anymore. We're actually really secular now. And so you see these kind of cases in Europe where, it's more and more you're seeing religious liberty rights just kind of wiped away in a lot of different European contexts or countries, at least what I'm reading in news reports. And even in this country, and maybe we could end with just applying your approach and thinking about a really interesting case. Controversial case out of New Mexico. I think the name is Elaine versus Hillock, a young evangelical Christian wedding photographer who refuses to photograph a same-sex wedding ceremony, and she tells them why in a conversation, and they sue her under the New Mexico Human Rights Act. And ultimately, the same-sex couple is vindicated at every level, including now, most recently, 2 weeks ago, the New Mexico State Supreme Court. And so I'm just, thinking about, there seems to be something which is incredibly new, but is very powerful, which is something like, new sexual autonomy rights now being enforced against people. And I'm wondering, so how would your approach deal with that case in particular?
Yeah, so it's a good question. I guess the first thing is that the first issue that it would look to is the historical practice with respect to the issue of exemption from generally applicable laws. So this is if the case were being analyzed under the Free Exercise Clause, of course. I mean, it might be, the issue might be a state statute or a federal statute and so on. But assuming that we were analyzing the case under the Free Exercise Clause, then we would have to look first to the historical purposes of the Free Exercise Clause. And so in my approach, although I'm not strictly speaking an originalist, original meaning counts for a lot for my approach. And in the book, I go through a number of early examples where dealing with the issue of exemption from generally applicable laws. And the conclusion that I come to is actually that there is a kind of division between the two approaches historically that scholars have identified is one that says, look, for constitutional purposes, there's never any requirement of exemption, and then the other approach says, well, yes, there is actually. Even the free exercise clause was contemplated to demand certain kinds of exemptions. And I kind of come to a middle view, and that is it depends on the nature of the exemption. So if we're dealing with a question like exemption from military service, when the issue of fighting the Revolutionary War was hot, the state is less likely to want to permit, or certainly to want to permit exemptions like that, and actually is a question about whether exemptions like that ought to be constitutionally required. But when the issue is less sort of burning hot, the interests at stake are less potent than the very sort of preservation of the state itself, then I think one sees greater arguments for religious exemption are more powerful. So then so transpose that kind of issue to the present. Well, what you see is how compelling, how desperate, how necessary is it that the same-sex couple have this particular photographer? Mm-hmm. Are there other photographers that are available? What's the nature of the service being provided, by the way? This is a photography at a wedding.
Yeah.
We're hardly in the category of the preservation of the security of the state. We're not even in the category, it seems to me, of the issue of oath-taking when one goes to court, right? That was another question, whether somebody could just affirm a statement as opposed to swearing the statement in court, because Quakers had issues with respect to swearing oaths. And, of course, the issue of swearing oaths is very, very important in that context, because you have to have reliable testimony in court. Are we even there when we're talking about the right to have a particular person photograph you at a wedding? It doesn't seem to me that we're there either, particularly in light of the fact that there are other photographers available at the ready to take these pictures. So what are the harms on the other side? So you see that already we're combining a kind of historical analysis with a weighing of value. What's the value on the other side? The value on the other side, it seems to me, is a kind of a dignitarian value that says, look, I feel hurt and denigrated, and my dignity is damaged when I seek services that a particular business provides to everybody else, which aren't provided to me. That is a harm, a cognizable harm. But from my point of view, given the concerns on the other side, and we haven't even talked about the dignitarian concerns of the photographer, it ought not to be powerful enough to compel someone against their will to photograph, to provide photographs. And in my view, the religious liberty objection and the request for exemption in a case like that ought to win under the Constitution.
Marc, perhaps on that hot button note, we should call it a day.
Let's call it a day.
I really do appreciate your time. The book is The Tragedy of Religious Freedom by Professor Marc Degirolami. Thank you so much for being with us today.
It's really been a pleasure, Richard. Thank you for having me.
This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawtalk.org, where you can subscribe, comment, find other episodes, and links relevant to today's conversation. Our email address is mail@libertylawtalk.org.